Welcome to Solutions from the Yard, a candid discussion about life behind bars and its effect on society. We'll discuss reintegration or re-entry back into the community post-incarceration. Your host for this episode is Charles Hopkins.
Welcome to this edition from Solutions from the Yard. I'm Charles Hopkins.
And I'm Michael Dickerson.
And I'm Dietrich Trent.
Today we're going to continue to talk about truth and sentencing. We have with us today Norman Ramel, distinguished attorney and advocate on all things criminal justice, trying to correct a lot of the injustice. And in our last conversation, we was going over the Sentencing Commission and what the Sentencing Commission consists of. But more importantly, we was talking about how the Sentencing Commission comes up with things they want to recommend to Congress for changing in the federal sentencing guidelines. And then once they come up with these things they want to look at, they open the floor up, or they open the conversation up to the public to make comments. And Norman and his organization said it had submitted comments on some things that they thought that would be instrumental in making sentencing fair across the board. And when we look at sentencing, we recognize that it's a lot of draconian sentences that's being handed out. We had this conversation earlier. Both Mike and Dietrich had got some sentences that was outlandish. I had a life sentence. Here to continue this conversation is Norman. Norman, you said, let's pick up where we left off at, because you had three observations that you wanted to make that y'all recognize that the Sentencing Commission is taking up and going to go forward in terms of trying to influence Congress to enact another standard relative to sentencing.
Right, that's exactly right. And last time we talked, they've announced their priorities for the coming year. There's a whole bunch of them, approximately 10. There are three in particular. Last time we talked about what they're doing with regard to alternatives to incarceration and diversion. We talked about acquitted conduct. But there's another one which I am extremely pleased to see them taking up, and I think it's something that really goes to the one of the key injustices in the system. They, under one of their priorities, they want to examine federal sentencing practices, and specifically, and this is their language, comparison of sentences imposed in cases of disposed of through trial versus plea. Now this gets to looking at what I and many others have called the trial penalty, which is the coercive ways that people are induced to plead guilty under the threat that if they exercise a fundamental right, such as the right to challenge unlawfully obtained evidence or the right to a trial itself, they get a geometrically greater sentence. Yeah. So it doesn't mean that they're going to tackle the problem yet,
right?
But at least now they're saying they want to actually begin to look at it, and they'll do, and they're going to compare the differential. Now I can say, because I've worked on numerous projects in this area, including a seminal report that was done during my tenure as executive director at the National Association of Criminal Defense Lawyers, and we found that there were in all kinds of offenses geometrically greater sentences for those who went to trial as opposed to those who entered a guilty plea. And this is across the board in the American criminal justice system, and it's got to be dealt with. So the fact that the commission is now actually going to look at it, hear from the public, they're going to see some really eye-opening things about how these injustices are perpetuated. Because very often, who goes to trial, right? Who goes to trial? It's people who have, it's two categories of people. It's people who are charged with such horrific offenses that there's no offer. Very few and far between. Right. You know, a guy who, commits an act of terrorism and kills a bunch of people, they're not going to make any offer. So they're going to go to trial because there's nothing to lose.
Right.
But the rest of the people who end up actually going to trial, and it's only like 3% now of cases actually go to trial, maybe even less, are people who legitimately have a defense and may very well be innocent.
Right.
And yet those people are the least blameworthy, the least culpable, and that yet by going to trial, if they lose, they may get a sentence that's far greater than the much more culpable person who, pled guilty, got the benefit of that, maybe even is cooperating against the person who's involved on a lesser level. And that's what we've really got to tackle.
And you know what? Let's unpack that
I'm
because
happy about that.
yeah, let's unpack that because when we look at it's coercion
At its best.
oh yes, and because this is the part of that they really need to examine. This conversation has to come out, and this information got to come forward. One, you put a person in a detention center. You leave them over. You can't make bail, so that's the first. Coercion. Can't make bail, cash bail. Can't make bail. Now I'm over there, and I got 4 co-defendants, and all of us got robbery of a 7-Eleven. We sold $40. Now I'm over there, and they saying that okay, but they don't. When my lawyer comes and say, well, they don't. You know, you don't have no identification. Don't have no, all the evidence say that if I go to trial, I'm gonna win. But they not trying to hear that. So what they do? Okay, postpone my case. Now I've been over to jail for 18 months. It ain't hard for me to just make a determination on what's gonna happen then. Because now I'm like, I've been over to jail 18 months. It's a sane asylum. So when they come and say, well, look, if you go to trial, it's a possibility you might get 50 years, but right now we're going to give you 20, and you got 18 months in on it. So you ain't going to have, and then start doing the math. You don't have to do but 16 more years. But you might get good time. But that's not a reality. But the reality is, like Norman just said, is that in terms of going to trial versus not going to trial, the encouragement is to go not go to trial and plead guilty. But the fact that they taking this up and looking at it, that opens the door for the conversation to say, what is the impact of all those factors that contribute to a person pleading guilty? Dietrich?
I have something to say about that because this is a very hot topic.
Mm-hmm.
And we see that misjustice happen a lot when it comes to the threat of a large sentence compared to a plea, right? So they put that on the table a lot. When I seen, they say we're gonna give you a plea to 30 years, but you're facing 77 years.
Yeah.
That's not a plea to no one. That's not a plea. And the fact that they gonna look at the fact that they willing to look at the practices of the pre-process of the plea and the sentencing process, I think there's something real about time.
Anyone who's been through the system or worked in the system knows that part of the process of entering a guilty plea is the accused having to say to the court that nobody's threatened or coerced them into pleading guilty. Yeah. That is the biggest fiction in
Fiction,
the criminal justice system in this
yeah.
country. Of course, what we have is legal coercion. And listen, I'm a defense lawyer. I have an ethical obligation to say to my client, listen, if you go to trial, there's a chance you're going to get 4 or 5 times what they're offering to you. That doesn't mean I don't want to take your case to trial, but you have to know that. And most people, if they have elderly parents or they have children, it's like you were saying, Charles, they want to go home. Mm-hmm. They want to get
this over with.
And I just want to say what the Sentencing Commission is doing is with regard to federal cases only. But this problem is pervasive throughout the whole system. And it also, we can't forget the minor crimes. Misdemeanors are not so minor. They can become enhancements later. They can prevent people from getting jobs, from getting all kinds of opportunities. And when you're faced with either take this plea or you're not going to be able to make bail, or in some places in the country, if you don't want to take this plea now, it's going to be at least 6 weeks till we can get you a lawyer, right? Yeah. People pleading guilty in some courts in this country without even having a lawyer. Yeah. And then you take it up to the higher level where you're facing the potential of extra years of your life. And, the way I look at it is, I think there's a place to give some benefit to people for accepting a responsibility. But it shouldn't be, the differential should not be so great that we actually nullify the very basic rights that we all have.
Yes.
Mike?
Yeah, well, I know full well of that because when I was in the Maryland system, I went to trial twice. And both times I lost, I got more time. The first time I went to trial, I was fighting the case. I was still out in society and I was going back and forth to trial. And I wound up going to trial, and just to make a long story short, I wound up losing. So the prosecutor at the time, I was under misdemeanor assault, but the misdemeanor assault had, according to their system, had a sentencing from anywhere from 0 to 30 years. So when I got found guilty, the prosecutor, first thing she said was, hey, let's go ahead and I move forward with sentencing. So she said, I want to move forward with sentencing because, the charge that I got charged with, people then got probation and everything for. But me and Dietrich had discussed before, I had a high profile case. So that's when, the prosecutor say, well, Judge, I recommend that Mr. Dickerson get 90 days in prison. So the judge was like, oh, well, it's so much about this case. I want to, review this first before we go rush into sentencing. So I came back 12 days later, because I never forget, I remember like it was yesterday. It was November the 7th of 1996 when I got found guilty. November the 19th, I wind up coming back for sentencing. And the judge said, man, further review of this case, I didn't know that he was the man and the suspect for these other charges, and I didn't know that. The 90-day recommendation, I'm gonna overrule that. I think that this man should get a harsher sentence. He said, I'm gonna give him 10 years, suspend everything but 5. So I'm like, how you go from go from the prosecutor recommending 90 days and you want to shoot all the way up to 10 years, suspend everything but 5. So that's what I wind up getting sentenced to. I got sentenced to 5 years and 5 years probation. So I wind up going back to trial again, won my appeal, went to trial again, wind up losing the trial again. So I lost again. And this time the judge, she was like, I think that, and she just went on just speculation in her own opinion. She said, I think that this man has something to do with what he's suspected of. And I'm up his sentence to 15 years. So she turned around and gave me 15 years. And basically, like you were saying, like they punish you for going to trial when the charge is a misdemeanor. The prosecutor recommended that I only do 90 days because I never had a charge like that before.
Yeah.
So this was appropriate sentencing was 90 days. That was appropriate. But here it is, just because I went to trial and lost, you give me this exorbitant rate of sentencing because I lost in trial, which when the charge is a misdemeanor, the average person do 90 days will get probation or 60 days. But you wanted to give me all these extras, extra lengthy sentence just because I went to trial and I was punished for going to trial when even when I got found not guilty, according to I never had a charge like that before. Why you just didn't sentence me to 90 days? Because still you getting a conviction and you still making me do time for the charge, the appropriate time for the charge. You giving me, if people was walking around with murder charges and they only had 12 years. I'm walking around with a misdemeanor with 15 years. I felt crazy.
Hey, Norman, in regard to these recommendations or these comments, we recognize that this is something that we're trying to influence the sentencing and have the Congress come in and say, well, and say this is codification and we codifying these to be lower. But let me ask you this here. Regardless of that, do the judges have the discretion for, say, a situation like when we talking about the plea? Do the judges have the discretion to develop a mindset to say, well, I'm going to look at these factors? No, I wasn't coerced. Nobody told me to be no coerced. But does the judge have the ability or under the circumstances to be able to probe?
Well, the judges under the sentencing guidelines, they have a certain amount of discretion. Mm-hmm. The guidelines are themselves advisory, but a lot of times, for example, we talked about acquitted conduct. The prosecutor may bring up other factors that trigger these enhancements, and many judges still feel very anchored to the guidelines. They feel like they should follow them, except in very limited circumstances, and then too. Remember that the mandatory minimum sentences that apply in so many different cases, they trump the guidelines. They supersede the guidelines. So if you get convicted of something that has a mandatory minimum, you're going to at least get the mandatory minimum. And of course, prosecutors are able to manipulate their charging in order to. So typically, I mean, in a typical narcotics case, for example, they don't have to charge a mandatory minimum, and many times they won't. But then on the eve of trial, they'll say, well, we're going to get a superseding indictment if you don't plead guilty, and now that's going to bring into play either a mandatory minimum or a higher guideline range.
In terms of the Sentencing Commission, when do they? So this is 23 into 24. They looking at the sentencing, making recommendation for a sentence to change it in 24. Try to get Congress to make a change in 24.
So this year in 23, that cycle is already done. They've done a number of amendments. There are a couple that are worth noting. For one thing, they have put into place some guidelines now that will make it possible for judges to use the First Step Act and more broadly to help people who have who can get resentenced because of extraordinary circumstances. The First Step Act has been in effect, but the commission, as I mentioned in our previous discussion, hadn't had a quorum. So now they've brought that up to date, which is a wonderful thing, and several thousand people have already benefited from that. Right. Many more will. The data that I've seen shows really excellent low recidivism rates. So that's a really great step forward. The other thing that they did in this current cycle was a couple of things related to criminal history. So that people with zero points, or people who were getting enhancements because they were under some form of punishment or previous conviction, they've loosened that up, and I think that's going to. And they've also, very importantly, they just recently decided to make it retroactive.
Yes, I just heard this from the prisons.
Yeah. Right. So there are going to be several thousand people who are going to be able to come home, and that'll take effect next year. Again, if Congress doesn't block it. But these other things that we've been talking about are what they're saying they're going to take up in this next year.
Yes, in 2024. Go ahead, Dietrich.
So I'm glad you just said what you just said, because a lot of brothers and sisters that I'm still in contact with, they under the impression that it's in law. They don't think that it's going to the Congress for a ruling or judgment. They think it's already in law because it came from the Sentencing Committee.
Well, I think hopefully we all have to hope that this works the way it has in the past, and Congress will not intercede.
Okay.
That would be really lamentable. But again, they don't. If Congress does nothing, this will take effect,
right?
And it takes effect on November 1. But the retroactivity, they've delayed that even a little bit further because they have to gear up the resources in order to be able to handle the influx of cases.
Yes. Mm-hmm. So as of today, it's only deal with those that came in after the ruling to win.
Right. So if they got if for example somebody now would qualify for getting zero criminal history, for getting the benefit of having no criminal history, they will be able to benefit if they're still in prison. Yeah. And similarly with the other changes related to criminal history, they will be able to benefit. So and the way these things work, because it's a grid, you've got your basic offense level, and then you've got your criminal history. Mm-hmm. These enhancements, if you're on the higher end, it's a lot of time that people are going to be able to hopefully save at home.
And going forward, what do you recommend in terms of like engaging the Sentencing Commission as an entity, and how do you think that people should respond to engaging them? Well,
to whatever extent possible, groups should definitely take advantage of these comment periods, or work with other groups that are doing it. I will say that there were a number of things that the group that I've been doing some work with, SEDEC, proposed that they didn't take up, and two of them that I would like to mention are one, and you've talked about this, mens rea reform. Mens rea is a fancy Latin term that refers to, well, let me put it this way. A crime has two parts to it. It has the act and it has the intent. Mm-hmm. So if you, just in most basic sense, if you kill another person, that's homicide. But If you did it with intent to kill them and premeditation, that might be murder. If you did it because you were acting recklessly, that might be manslaughter. If you were negligent, it might be criminally negligent homicide. If you were acting in self-defense, it's not even a crime, right? All crimes should have a clear intent requirement before people can be convicted, and that's not the case. And so we've been proposing, it's another issue that I've been working on for many, many years actually, is to look at all the statutes and analyze whether there are adequate intent requirements so that people are really they're only being prosecuted and punished for the things that they actually intended to do. The other thing that we've proposed, that Zedek has proposed, is to have a presumptive maximum sentence that at least initially would apply to nonviolent offenders. But that would include people who are charged with controlled substance offenses, so not just economic crime. And that basically, except if there were a jury finding beyond a reasonable doubt of certain aggravating circumstances, you could not go above it. And I think the suggestion was 10 years. And this really gets to the heart of what, we have to think really about what is punishment, why do we do it, and what are we trying to get for it? Because most people, 10 years is a long, long time.
Yes.
And people change.
Yes.
And we know that. We know, and when I was doing that clemency work and had a hand in reviewing a lot of those cases, I was astonished at people who had no hope of ever being free again, at what they had done to change their lives. People who didn't have a single infraction, right? Who outside here, and myself included, doesn't do something wrong at some point. These people, so we have to, if we start from the presumption that, except where there are these really bad aggravating factors, everybody should, be eligible to come home in a reasonable amount of time.
Yeah, that's right.
That's where we need to go.
And wait a minute. And with in terms of the memories, and I like the way you articulate it. But this one came to my mind and you have to be found guilty beyond a reasonable doubt in all the elements of the crime. So if you don't have a clear memories, and that's a part of my crime, how do I get found guilty of that crime? If you don't have a clear set of intent, if the intent is not, because like in the state of Maryland, like they got what they call felony murder. So if you commit kill in the course of the felony, then that's felony murder. So the robbery, the underlying felony is the determining factor, not what happened after the fact. But that's a big conversation to have now, like to get rid of felony murder.
Yeah.
Go ahead, Dietrich.
No, I wanted to speak about the 10 years as the cap. I wanted to know where they got that from, because that's a saying inside the walls in there. You do 10 years, you should be some type of change in some trajectory of changing where you're going at or where you've been at in prison. You need 10 more years. It's like 10 years is a cutoff period for someone to really change and get control of their life and direct it in a different path. And for someone that for non-violent crime, I think that should be the cap for just saying, because 10 years is a lot of time, period. Of anybody's life. The society flipping 5. So we talking about, yeah, that's true. Society flipping, no, society flipping 5. I'm just saying, and then, so you told the society flipping it 2 times. 10 years is sufficient for someone to change their life. And I think, like right now, they got with the Ivor coming up, you heard of the Ivor, they make guys do 20 years, right? Before you eligible for any type of relief. That's double what they trying to set for non-mandatory. So I'm all in agreement.
I like Mike said something one time. We was talking about, we didn't know, like, well, I know this when we got out. Say, oh, I don't know what I'm going to do, but I'm not going to go back to prison or something to that. I feel like I ain't had no plan on, I ain't had no roadmap on what I'm going to do in society, but I knew that it didn't involve going back. And to that conversation on where you was talking about how the clemency, how people had changed, and they got the DC Clemency Board, Board, and we're trying to advocate for men and women to become part of that process. And this is the problem with this system, is that they don't recognize that a person can change and a person will change. I've seen people come get sentenced, and the first thing they say out their mouth when they get sentenced, I'm not that person that did this. Today I'm not that person.
I wanted to ask a question before we go, because you were saying something about like them having certain, like, you know, manslaughter, things of that nature, right? Because if I'm mistaken, DC don't have a self-defense law, right?
No.
So that, what you was just saying, would that enact a self-defense law in DC? Because we don't even have, like, you know, the lowest you can go is manslaughter.
No, it wouldn't. I'm not familiar with the DC situation. I can't imagine that there's no circumstance in which acting in self-defense would not result in you know, I mean, it's sort of a basic fundamental human right. If you're, so I'm not sure how that plays out, but the idea though is, I use that as an example because it's so clear when you're talking about something. I mean, it's obviously one of the most serious things is taking another human life, but the idea of that we accept the fact that what your mental state is changes dramatically, whether you know how much you should be punished, frankly, because somebody, you know, if you hire a hitman to kill somebody, right, that's a very intentional, cold-blooded, you know, killing. On the other hand, if you're in a bar fight and you know, in the middle of that fight, you strike somebody in such a way that they die, that's a very different crime, right? So the law, you know, generally, I can't speak to DC, but the law generally recognizes also that if you didn't have any intent to take somebody's life, you know, then, you know, it's not a crime.
Right.
Okay, and thank you, Norman. As we close on this edition of Solution from y'all, we want to thank you, Norman, for taking your time out to educate our audience on all things sentencing and truth in sentencing. When we talk about truth in sentencing, we really mean sentencing being true based on the facts and the circumstances of the crime that a person commit, and not based on the politics of the season. Thank you very much.
Thank you for having me.
Thank y'all for joining us.
Thank you for coming to Solution from y'all.
Thank you.
Voices for a Second Chance is a comprehensive reentry program that provides culturally appropriate, trauma-informed, gender-specific, and peer-based services. Voices for a Second Chance bridges the gap from incarceration to community for tens of thousands of men and women in the District of Columbia. Our goal is for our clients to achieve a state of well-being and care as they transition from incarceration to community. You can help us continue our mission. For more information or to provide financial support, go to info@vscdc.org or visit www.vscdc.org.